Welcome back. We now move on to agenda item 4, which is consideration of the Dog Theft Scotland Bill at stage 2. And a welcome to the meeting, Maurice Golding, the member in charge of the bill, who is supported by officials from the Parliament's Non-Government Bills Unit, and also Siobhan Brown, the Minister for Victims and Community Safety, who is supported by Scottish Government officials, and will shortly be joined by Rachel Hamilton, who has lodged amendments on the bill. Officials seated at the table are here to support the member in charge, but are not permitted to speak in the debate on amendments. Before we begin proceedings, I will briefly explain the Stage 2 procedures for members of the public and to bring myself up to speed as well, to be honest. There will be one debate on each group of amendments. I will call the member who lodged the first amendment in that group to speak to and move that amendment, and to speak to all the other amendments in the group. Members who have not lodged amendments in the group, but who wish to speak, should catch my attention. If he has already not spoken on the group, I will then invite the member in charge to contribute to the debate. The debate on the group will be concluded by me inviting the member who moved the first amendment in the group to wind up. Following the debate on each group, I will check whether the member who moved the first amendment in the group wishes to press to a vote or to withdraw it. If they wish to press ahead, I will put the question on that amendment. If a member wishes to withdraw their amendment after it has been moved, they must seek the agreement of other members to do so. If any member present objects, the committee immediately moves to the vote on the amendment. If any member does not want to move their amendment, when called, they should say "not moved." Please note that any other member present may move such an amendment. If no one moves the amendment, I will immediately call the next amendment on the marshalled list. Only committee members are allowed to vote. Voting in any division is by a show of hands, but it's important that each member keeps their hands clearly raised until the clerk has recorded the vote. The committee is required to indicate formally that it has considered and agreed to each section of the bill, so I'll put a question on each section at the appropriate point. And we don't have any members attending or participating remotely. So I'll now move on to the marshal list for amendments for stage 2. And I call Amendment 19 in the name of Rachel Hamilton, grouped with Amendment 9. Rachel Hamilton to move Amendment 19 and speak to both amendments in the group.
I move those amendments, Convener, and thank you. Amendment 19 requires courts to consider both the emotional and the operational impact when sentencing for the theft of a working gun dog. This amendment ensures that the court must take into account the operational loss suffered by the lawful owner and the emotional impact of the theft, not only on the owner but also on the others affected by the loss. Gun dogs are trained working animals and often with high financial and operational value, whose theft disrupts land management, shooting days and livelihoods, and causes acute welfare and owner trauma. And this was evident in a case of dogs that were taken from my own constituency in the Borders, which was highly covered by the media. Current common law theft can treat dogs like property, and a specific offence recognises the sentient and working status of gun dogs. This amendment recognises the unique role that working dogs play and the serious consequences that theft can have. In regard to Amendment 9, lodged by my colleague Maurice Golding, which removes Section 3, I'm aware that this reflects the Government's existing commitment to expand the range of offences where victim statements would be permitted, and was recommended by the committee that this should be considered within the wider context of this, rather than within the bill. I'd therefore like to add my support to Amendment 9 and hope the Government's commitment to expand the range of offences where victim statements would be permitted, and hopes to see that cover dog theft too. Thank you.
Thank you. Maurice Golding to speak to Amendment 9 and other amendments in the group.
Thank you, Convener. I will start with Rachel Hamilton's Amendment 19. First of all, emotional impact of the theft of a dog should be recognised in law. That is the main purpose of this bill. And I also recognise that there are situations where there's an operational loss or loss of earnings for a person who owns a working dog. Whilst I don't want to jump ahead to the debate on a future group, I would point out that amendments to 1 to 8 in my name do open up the possibility of the aggravation in Section 2 being widened by regulations to include working dogs and potentially working gun dogs, although, of course, that would be a matter for Scottish ministers. Amendment 19 would place a specific type of dog, a working gun dog, at the heart of Section 1 offence. And I understand Rachel Hamilton's policy intention in seeking to ensure that the impact on an owner of working gun dogs is fully taken into account in the criminal justice system when such a dog is stolen. However, in my view, singling out working gun dogs over other dogs here gives a preeminence to theft of those dogs over the theft of other dogs in statute. It also singles the theft of such dogs out for special treatment in sentencing. I'm not sure, for example, where this sits alongside aggravations in Section 2, although I note Ms Hamilton has amendments in that section as well. The theft of an assistance dog is not singled out in Section 1 in the same way that Amendment 19 singles out theft of working gun dog. This particular issue in relation to working gun dogs does not explicitly come up during Stage 1 scrutiny by the committee. Before changing the law on this issue, I would want there to be consultation and scrutiny of these issues. Turning now to my amendment in this group, Amendment 9, all of the amendments I've lodged today have been developed following discussions with the Scottish Government, and I thank the Minister for her engagement on that. At the outset, I want to say that I appreciate the support in a very short period of time to develop the amendments which are before the committee today. This amendment, Amendment 9, has been lodged following careful discussion and feedback from the committee's Stage 1 report. I believe that the emotional and welfare impact on owners and indeed the dog itself should be taken into account when sentence is being handed down. However, the Parliament has recently legislated to provide for victim impact statements in solemn cases. I accept that to make provision through this bill for such statements in summary cases of dog theft would create a precedent that government and stakeholders, such as the Scottish Courts and Tribunal Service, may not welcome. As such, having tested the issue, I am prepared to accept that there is not an appetite to include victim statements in the bill, and therefore I have lodged this amendment to that effect. However, I do believe that the emotional impact of a dog being stolen should be taken seriously. Thank you.
Thank you. Any other members? No. Minister.
Thank you very much and good morning, committee. Convener, can I just start by confirming to the committee that Mr Golden and I have had really constructive discussions since Stage 1, and I'm pleased that the government has been able to support him with the amendments that he's lodged at Stage 2 and will be supporting all of them. Unfortunately, I'm not able to support any of the amendments in the name of Rachel Hamilton. While I understand the sentiments behind Amendment 19 in Ms Hamilton's name, it is the wrong approach. Sentencing in criminal cases is for the independent courts, subject to certain parameters set out in law. Amendment 19 would require the court to consider two specific matters when sentencing for the dog theft offence, but only if the dog in question was a working gun dog. No definition of the expression working gun dog is included with this amendment. The two matters it specifies is operational loss and emotional loss are matters for the court that the matters for the court will already take into account as part of their consideration of all relevant facts and circumstances in a case. And specifying these two particular matters is unnecessary and it risks skewing the sentencing process by giving undue prominence to the specified matters. Yes.
Would the Minister be open to considering looking at the impact of the theft of working dogs? Because at the moment we know that there are around about 1,800 thefts of dogs in the UK, but we don't know how many of those are working dogs, and there is an issue with the operational loss to the income and the training time and all the rest of it. And if a court is not aware of those situations, how can they make a determination on the emotional loss and the financial loss, because they're leading blind?
Yep. No, absolutely. And I don't know if Ms Hamilton's aware of the work. There was a summit last year for that Minister Jim Felley and myself had regarding dog legislation and dog welfare. And from that there was an expert advisory group that has been set up. There's been quite a lot of progress. I know I updated the committee on this at stage 1, but this is one of the things, and I'll come into it at another stage, is this we're really, given after stage 1 and the concerns that were raised regarding working dogs in general, not just gun dogs, but working dogs in general, one of the amendments that Mr Golden has brought forward is that we will be giving the experts in the advisory group work to do to define working dog, which is one of the things that we're looking forward, and that's why we can't support this amendment at this stage. And they're also looking at welfare and a range of issues that I can go into, or maybe it's better that I could write to Ms Hamilton to sort of advise her of all the work that's going on in the background that you might not be aware of.
That's very generous, Convener, of the Minister. And what I would just like to come back on, if I may, is to say that I feel quite positive about that, because I do think that there is still something that could be brought back at stage 3 to recognise not only the work that the working group are doing, but to understand the necessity to recognise working dogs in this bill.
Mm-hmm. Absolutely,
yeah,
and that's a main part of Mr Golden's amendments as well. But if I can just carry on just regarding the amendments, just in the two particular matters unnecessary and skewing the sentencing process, it also risks creating doubt over whether the court should take into account of the two specified matters where the dog stolen is not a working gun dog. So that goes back to the definition of what is a working dog, and we want them all covered except for just a working gun dog. Obviously, the theft of other types of working dog can cause operational losses too, and the theft of any dog, whether it's operational loss or not, is likely to have an emotional impact on everyone. It would be unhelpful to frame in a law in a way that signals these are matters for the courts that need to consider in sentencing when the dog stolen is just of one particular kind. So I would urge the committee to reject Amendment 19. Turning to Amendment 9, I would encourage members to support this amendment, which would remove Section 3 from the bill and ensure that dog theft offence is treated consistently with all other offences prosecuted under the solemn procedure. As Mr Golden said in his opening speech, the recent Victims, Witnesses and Justice Reform Scotland Act includes provision to extend victim impact statements to all solemn cases, and that will include cases of dog theft prosecuted under solemn procedure. That is the right approach, and I urge members to support Amendment number 9.
Rachel Hamilton to wind up and press or withdraw Amendment 19.
Thank you, Convener, and I appreciate the comments made by both Maurice Golding and the Minister regarding my amendments. I do, as I said to the Minister, feel that there is a chink of light in that there could be some solace, I suppose, for those who have experienced this type of theft, particularly when they have working dogs, particularly gun dogs, because we know that gun dogs are a recognised target. They are specific, they're valuable, they're of certain breeds that can only be working dogs, and that because of the rurality of the accommodation, they can be targets for theft. So I won't be pressing this amendment, Convener, but I will be meeting with the Minister to discuss it further. Thank you.
The member has indicated that they wish to withdraw the amendment. Does any member object? No. I call amendment 8. I beg your pardon. Yeah, well, that's the end of the section. The question is that section 1 be agreed to. Are we all agreed? We are agreed. I now call amendment 1 in the name of Maurice Golden, grouped with amendments as shown in the groupings. Maurice Golden to move amendment 1 and speak to all the amendments in the group.
Thank you, Convener, and I move Amendment 1. So looking at all my amendments in this group, 1 to 8, this suite of amendments seeks to ensure that the aggravation can be extended by regulations to apply in relation to the theft of dogs that would not ordinarily be considered assistance dogs. They replace the label assistance dog with the broader expression helper dog. This broader term enables Scottish ministers to extend the definition of helper dog by regulations. In practice, this would allow Scottish ministers to extend the definition to include, for example, service dogs and working dogs, should they choose to do so. These amendments do not affect the aggravations operation in relation to assistance dogs as defined by the Equality Act 2010. Happy to.
Much. So I would like to get some clarification, and I think you are doing that, around these amendments. I'm changing the term assistant dog to helper dog. I've heard concerns that using a different term to the established legal one could create operational issues for law enforcement, which may undermine what Section 2 intends to achieve. So if you could go into that a little bit more fully to allay these concerns that have been brought to me, that would be very welcome. Thank you.
Yeah, happy to. I mean, ultimately, these amendments do not affect the aggravations operation in relation to assistance dogs. The amendments 1, 2, 6, 7 and 8 replace the references to assistance dog with helper dog, and amendments 3 and 4 slightly reword section 2(3) to make clear that a helper dog is what a helper dog is, namely an assistance dog as defined under the Equality Act 2010, and a dog of a category prescribed by ministers and regulations. So ultimately, this and these suite of amendments are about an opportunity for flexibility going forward to broaden the definition and allow, perhaps in due course, through experts and ultimately with the decision from Scottish ministers, being able to broaden that definition, and actually speaks to much of Rachel Hamilton's amendment today. In terms of Rachel Hamilton's amendments in this, yeah.
Sorry. Just on that, so what you're saying is these changes would allow assistance dog to be defined in the legislation, but could expand that to working dogs or other dogs for use different purposes. So it would be a much wider definition if government decided to define it in such a way. Yes.
So the assistance dogs, if you like, are treated the same. The change is that assistance dogs and potentially other categories could be included in this. That is what amendments 1 to 8 seek to achieve. In terms of Rachel Hamilton's Amendment 20, this requires regulations made under subsection 2B to include working gun dogs and working dogs as a category of helper dog. Whilst I recognise the policy intention behind this amendment, it is my view that if Parliament provides ministers with a regulation-making power, then ministers should have an element of discretion to exercise that power, albeit the exercise of that power is subject to parliamentary procedure at a future juncture. Happy to.
Does that mean then that if you're happy that Scottish ministers have the ability to make a further definition by regulation, that you support Amendment 20?
Ultimately, I think that in the fullness of time and after consultation with the expert working group, that working dogs and working gun dogs should be helper dogs if the expert advisory group and indeed Scottish ministers choose to go down that path. I think Amendment 20 is, in my view, too restrictive and prescriptive, and ultimately Amendments 1 to 8 enable the policy intent behind Amendment 20 to be achieved in any event, and ultimately any regulations will be subject to parliamentary scrutiny, not by myself. In terms of Amendments 21 and 22, these both create new sections after Section 2 and have a similar effect to each other, albeit Amendment 22 is specific to working gun dogs, whilst Amendment 21 relates to working dogs more generally. These amendments provide for an aggravation in respect of these dogs. In relation to both amendments, I would simply reiterate my earlier point that my Amendments 1 to 8 provide ministers with a regulation-making power to designate different categories of dogs as helper dogs. This could include working dogs or working gun dogs. And I understand that ministers would develop regulations in concert with its expert working group. I therefore think it would be prudent to allow the working group and ministers the time to consider whether such aggravations should be applied to, for example, working dogs or working gun dogs. Thank you.
Rachel Hamilton to speak to Amendment 20 and other amendments in the group.
Thank you, Convener. My amendments in this group establish that the theft of a working dog includes working gun dogs and should be treated as a specific aggravated offence. Amendment 21 introduces an aggravation for the theft of any working dog using the definition found in Section 6 of the Animal Welfare Act 2006. And Amendment 22 applies the same principles specifically to working gun dogs. And these amendments define working gun dogs to include those used in sheep herding, policing, rescue operations, pest control and lawful shooting. Working gun dogs are defined as dogs used in shooting and land management work. And Amendment 20 would work alongside Maurice Golding's amendments, which would expand the aggravation in Section 2 of the bill. Amendment 20 would require that any regulations prescribing categories of helper dogs must include working dogs and other working dogs. It also allows Scottish ministers to expand these definitions later by regulation. And under these amendments, courts must state that the offence is aggravated, record it as such, take the aggravation into account when sentencing, and explain whether the sentence is different because of it or why it is not. These amendments ensure that the law reflects the seriousness, as I have explained before, of stealing working dogs, which play an important role in rural and agricultural communities. On what Maurice Golding explained regarding his amendments 1 to 8, I recognise that this can be dealt with in guidelines by Scottish ministers, but I don't believe that it recognises the full extent of my policy intent by describing a specific group of dogs as helper dogs. Thank you.
Thank you. Minister.
Thank you very much, Convener. As I made clear at stage 1 debate, the Scottish Government supports the creation of the aggravated offence for assistance dogs. Having listened to MSPs during the debate, the Scottish Government also supports extending the aggravated offence to cover other categories of dogs which may not naturally be called assistance dogs. And if I could just go to your point, Ariane, that I know that there was a research paper that was given to the committee during the passing of this legislation from the SSPCA, which highlighted the complexities of the definition. And this is why we will engage with the expert working group, which I'll come on to explain, for the experts to define what a working dog is. And we will, Scottish Government will also then, as if the bill passes at stage 3, we will engage with all our justice partners to ensure that implementation is straightforward there. So,
Would the Minister take an
yes.
Just for clarity on that, and the concerns that have been raised with me, they're around the concerns around using a different term to the established legal one that could create operational issues for law enforcement. So if you could give me some certainty that you are aware of that and that you will be addressing that.
Yes, absolutely, and that's where we will, like, if anybody wants to get in touch with Mr Golden before stage 3, and we'll work with him to if there's anything that you want to put forward at stage 3, but we are aware of the complexity of the definition, and this is why we are putting this group in place to do the definition moving forward. Yes? Yep.
Would it be necessary to update sentencing guidelines to include the definition of some of the stated definitions that I have just read out, including working dogs?
I wouldn't think it would be at this stage, but it's something that could be considered.
Okay.
Okay. If I could just move on, just because I wanted to touch on a few points there. As I said, we are also support the extending of the aggravated offence to cover categories of dog which may not naturally be called an assistance dog. For example, working dogs such as farm dogs and gun dogs and service dogs with the police, as well as support dogs where owners receive specific forms of support from their dog that go way beyond just being a pet. As such, I'm pleased that Amendments 1 to 8 will adjust the enabling power in Section 2 of the bill to ensure the full range of helper dogs can be added to the aggravated offence in the future. The Scottish Government established the Responsible Dog Ownership Expert Advisory Group following last year's Dog Summit, and it includes key dog welfare stakeholders such as the Dogs Trust and the Scottish SPCA, and I have commissioned that group to consider what further types of helper dogs could be added to the aggravation and, crucially, how best to define them. And this is with a view to using the enabling power during implementation to add in these further categories so that the aggravation applies. It is important that the criminal law is clear and therefore definitions matter, and that is why I do not support Rachel Hamilton's amendment in this group. Properly identifying different types of dogs in legislation is challenging, and I think it's really right that we listen to the experts in this area. Yes?
Thinking about the discussions of expert working group regarding helper dogs, is there an issue that has come up around ownership versus handlers of certain dogs? For instance, expert sniffer dogs used at airports might not necessarily be owned by the handler,
Yeah.
but that handler essentially is taking care of the dog, takes it home every night as well. So has that been part of the discussions around the clarity required regarding ownership versus handler?
The group has only met last month for the first time, and they will be meeting with, as the legislation passes, they will be taking all these issues on board. I'm sure they'll be listening to all the issues that are raised today and taking them all on board. Yes?
Thank you to the Minister for taking an intervention. If the group has only met once, why is the Minister not taking into account the kind of the amendments that I've brought forward when she doesn't have a clear guideline as to the recommendations of the working group?
No, we do. I've got a lot of information on this work. I'm not going to go through all the detail, and I'm happy to get in touch and send this to Rachel Hamilton. There's a lot of work going on. This legislation is just going through. There was a meeting last month with the expert advisory group that felt they needed to be involved with this dogs theft bill. We have commissioned the group moving forward, if the bill passes, that they will be tasked with the definition as we move forward.
Okay, thank you.
So, as I said, it is important that criminal law is clear and therefore definitions matter. That's why we can't support the amendments, and I think it's really important that we listen to experts in this area. Moving to amendments 20, 21 and 22, that would preempt the work of the expert advisory group by providing definitions of certain types of dogs, namely working dogs and gun dogs in the primary legislation. And also by creating this provision in primary legislation and not secondary, any future change would mean that primary legislation, it would be changing the initial primary legislation, and that is disproportionate, and it's not a good use of parliamentary time. In addition, Convener, the definition of a working gun dog used in Amendments 20 and 22 is especially problematic. It begins by talking about breeds, but ends with the training and the role of individual dogs. The clear problems with the definition are enough on their own to mean that I cannot support either Amendment 20 or 22. The major issue with Amendment 21, which is also relevant to Amendment 22, is that it cuts across Section 2 as amended by Maurice Golden's Amendments 1 to 8, and creating separate bases for effectively the same aggravation risks causing confusion about which of the enabling powers in the legislation can be used to specify which type of dog. This is because of the presumption in law that a more specific rule in legislation will be seen as parliamentary intent, where a general rule in legislation also exists. It may also lead in due course to confusion amongst prosecutors about which aggravation to charge. The amended Section 2 will be able to create aggravations for the theft of any dogs that would be covered by the sections that Amendments 21 and 22 would insert into the bill. It is better for the operation of the law to have one section dealing clearly with the aggravation of the offence, and as I've said, criminal law does need to be clear. I would therefore ask members to support Maurice Golden's amendment in this group and reject those of Rachel Hamilton, and I would like to offer Ms Hamilton, if she would like to not press this and discuss this with me prior to stage 3 and officials, or even the expert advisory group, I'm happy to enable that.
Thank you, Minister. Maurice Golden to wind up.
Thanks. I think that's been a very helpful debate on Group 2, and I don't have anything more to add. Thank you.
Thank you. The question is that Amendment 1 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendments 2, 3, 4 and 5, all in the name of Maurice Golden, and all previously debated with Amendment 1, and I invite Maurice Golden to move Amendments 2 to 5 en bloc. Does any...
I'm sorry.
Thank you.
Moved on block.
Does any member object to a single question being put on Amendments 2 to 5? We have no objection. If no member objects, the question is that Amendments 2 to 5 are agreed to. Are we all agreed? Yes. We are agreed. Thank you. I call Amendment 20 in the name of Rachel Hamilton, already debated with Amendment 1. Rachel Hamilton, to move or not move?
On the basis of what the Minister said, I will not move.
The amendment has not been moved, so it will not be considered. I call Amendments 6, 7 and 8, all in the name of Maurice Golden, and all previously debated with Amendment 1. I invite Maurice Golden to move Amendments 6 to 8 en bloc.
Moved on block.
Does any member object to a single question being put to on Amendment 6 to 8? No. The question is that Amendments 6 to 8 are agreed to. Are we all agreed? Yes. We are all agreed. The question is that Section 2 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 21 in the name of Rachel Hamilton, already debated with Amendment 1. Rachel Hamilton, to move or not move?
Not moved.
The amendment has not been moved, so will not be considered. I call Amendment 22 in the name of Rachel Hamilton, already debated with Amendment 1. Rachel Hamilton, to move or not move?
Not moved.
The amendment has not been moved, so will not be considered. I call Amendment 9 in the name of Maurice Golden, already debated with Amendment 19. Maurice Golden, to move formally.
Moved.
The question is that Amendment 9 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 23 in the name of Rachel Hamilton in a group on its own. Rachel Hamilton, to move and speak to Amendment 23.
Thank you, Convener, and I move the amendment. Amendment 23 requires ministers to undertake research into areas where working gun dogs are most at risk of being stolen or unlawfully kept. And following the completion of this research, ministers must within 1 year establish a grant or loan scheme to support owners in improving kennel security in high-risk areas. In the UK and across Scotland, data shows, as I've already indicated, that dog theft remains a real issue for working dog owners, and as industry analysts estimate, 1,800 UK dog thefts are carried out, and that was the figures from 2024, meaning that's around 5 thefts per day, and often with low recovery rates. And furthermore, reports suggest that around 50% of stolen dogs every year relate to dogs in the working dog category across the UK, with the most commonly stolen gun dogs being Cocker and working spaniels, Springer Spaniels and Labradors. We know that working gun dogs are vulnerable to theft because, as I have already indicated, they have a very high market value. They undergo specialist training, and if they're in a kennel, then they're exposed to theft. And a properly trained gun dog might be worth several £1,000s and take up to 2 years to train, which means the theft of the working dog is not only financially rewarding to a criminal, but also disrupts the land management, as we've talked about, the shooting days, and causes significant emotional trauma. The proposed kennel grant scheme would support professional gun dog keepers and shoots in high-risk areas to upgrade security to recommend measures such as CCTV, floodlighting and alarmed padlocks. By identifying the areas most at risk and offering financial support, this amendment aims to reduce the incidence of theft and better protect these animals, particularly in rural areas.
Thank you. Minister.
Thank you, Convener. Convener, I don't support this amendment, which would commit the Scottish Government to provide direct financial assistance to improve the security of kennels where working gun dogs are kept based on geographical areas. The targeting of this financial assistance is to be informed by research carried out by the Scottish Government into areas where working gun dogs are at greatest risk of being stolen. Now, my personal view, this is an entirely inappropriate use of public funds. It is for those that own working dogs and all of us that own dogs to ensure that security is adequate in the same way as any other organisation does for their resources. There is a significant risk that funding such a scheme, or indeed even the research, could become a perverse incentive not to ensure adequate security if it is seen as a way of having the security paid by the taxpayer, particularly if this is supposed to be based on where risk is greatest. The risk would be greatest where there is least security. For those reasons, I ask the members to reject this amendment.
Thank you. Boris Golden.
Thank you, Convener. I have a number of concerns with this particular amendment. Firstly, I'm not entirely clear why a specific fund would be created to upgrade the security of kennels housing working gun dogs and not other dogs. It would seem to me to create an inequity between those dogs and other dogs, such as working dogs, assistance dogs, or indeed dogs generally. I am not clear why those dogs should receive protection not afforded to other dogs. Secondly, this amendment appears to carry with it significant cost, and that causes me concern. This is currently a relatively inexpensive bill. This amendment, if agreed, would potentially change this, and the benefit would only be experienced by a small proportion of dogs and owners. My bill already creates an offence of the theft of all dogs, including a working gun dog. Furthermore, the amendments in my name, which the committee has just agreed, mean that the government could create an aggravation for working gun dogs via regulations, should they choose to do so. Amendment 23 goes significantly beyond this and ultimately is potentially expensive, too specific to a particular type of dog, and is fraught with unintended consequences. Thank you, Convener.
Thank you. Rachel Hamilton, to wind up, press or withdraw Amendment 23.
I have no further comments and I will not press.
You won't press. Okay, the member has indicated they do not want to press, so it will not be considered. I call Amendment 10 in the name of Maurice Golden, grouped with amendments as shown in the groupings. And I point out that if Amendment 14 is agreed to, I cannot call Amendment 24 as a pre-emption. Maurice Golden to move Amendment 10 and speak to all amendments in the group.
Thank you, Convener. Happy to move Amendment 10. This suite of amendments has been lodged following discussions with the Minister and responds to the committee's Stage 1 report. Concerns were raised at Stage 1 about the burden the reporting requirement would place on bodies, with some considering an annual reporting requirement in respect of this issue to be overly onerous. As such, I have listened to those concerns and am seeking to amend Section 4 to provide for a one-off reporting requirement after 3 years and for the level of information required to be reported on to be reduced down to number of cases, number of prosecutions and number of convictions. There is, however, nothing preventing this report from including information that was previously in Section 4. Under subsection 3, the Scottish Ministers may add other information which they consider to be appropriate. However, they are now not required to, for example, report on the number of cases prosecuted under common law or the number of cases prosecuted under summary or solemn procedure. Now, turning to each individual amendment. Amendment 11 clarifies that the information the report is to contain is to relate to things that have happened over the course of the 3-year reporting period. Amendment 12 amends the information which is required to be reported on. Amendment 13 is a technical amendment to ensure that the bill is clear that this reference to length of sentence in this section is to a custodial sentence as opposed to, for example, the period of a work requirement imposed under community payback order. Amendment 14 removes the requirement to report on cases of dog theft prosecuted under existing common law offence of theft. Amendment 16 is a consequential amendment. And finally, Amendment 15 is a minor and technical amendment. Therefore, whilst I believe that strongly that good data collection and reporting to Parliament are important, I do also want to balance this with proportionality and allowing bodies such as Police Scotland and the Crown Office and Procurator Fiscal Service to get on with their jobs, and I've listened to concerns raised at Stage 1. I was therefore happy to lodge these amendments, which I believe strike an appropriate balance, and thank the Minister and their officials for their constructive engagement in helping me to develop these amendments. Turning to Rachel Hamilton's amendments, 24 to 28. Once again, I thank Rachel Hamilton for her amendments. As with her other amendments in relation to working gun dogs, I remain to be persuaded of the need for them in the bill. I would have no objections to the report under Section 4 providing information on working gun dogs. However, I am not sure that to specify that on the face of the bill is necessarily helpful, as it would mean making a separate case for working gun dogs. I've just spoken about Amendments 10 to 16, which reduce the amount of information that is required to be reported on. I have done this following discussions with the Scottish Government, recognising the need to balance good data collection and reporting mechanisms with proportionality. My fear with Amendments 24 to 26 is that they go against this approach and place overly burdensome duties on bodies in relation to a very specific type of dog. Amendments 27 and 28 define working gun dog in two alternative ways. As mentioned earlier, I would have concern about the definition used in Amendment 27 in respect of the way it conflates breeds and training. More broadly, I am encouraged that Rachel Hamilton will be engaging with the Minister following this Stage 2, and I believe that together there should be consensus to cover much of those issues contained in Ms Hamilton's amendments. Thank you.
Thank you, Mr Golding. I now call Rachel Hamilton to speak to Amendment 24 and other amendments in the group.
Convener, it seems as my amendments aren't going to be successful today from the comments made by the Minister and Maurice Golding. But I would say that, you know, without these working dogs, the country sports would not be possible. And we know that they are worth millions to the economy. And, for example, shooting would not be possible across Scotland without them. So I don't want the role of working dogs to be devalued. And I know that both the Minister and Maurice Golding are very respectful of the intent of these amendments. But my amendments in this group aim to strengthen and expand the reporting and monitoring duties within the bill. Amendment 24 provides that each of the reporting requirement under subsection A to G should also be reported on in relation to working gun dogs. Amendment 25 adds that the annual report must also include information on the number of dogs that are returned to their owners. 28 adds a reporting requirement into the Section 4 annual report by ministers to include the area where dog theft reports take place. This would be reported on every year, and I think that is important, and it's perhaps something that the working group may commit to looking at. Amendment 27 provides the definition of working gun dog for the purposes of Section 4 and 5. And finally, Amendment 28 allows the definition to be set entirely by regulation, offering flexibility to adapt to future needs. And I want to say that to the committee that I do bring all of these amendments today forward in good faith. And I know that when a member brings forward a bill, that they have to work with the government and they have to listen to the concerns of the committee and also the government. So in a way, there has to be some sort of compromise and negotiation around the bill itself. But I do hope that listening to both Maurice Golding and the Minister, that they will take all these amendments in good faith. I am not planning to move these amendments, if that helps, Convener.
Thank you. Minister.
Thank you, Convener. Yes, I could go through my spiel, but if the member isn't going to move the amendment, I'll support that.
Okay. Maurice Golding to wind up.
Nothing further to add, Convener.
Thank you. The question is that Amendment 10 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendments 11, 12 and 13, all in the name of Maurice Golding and all previously debated with Amendment 10. And I invite Maurice Golding to move Amendment 10 to 13 en bloc.
Moved en bloc.
I beg your pardon, 11 to 13.
Yeah.
Thank you. Does any member object to a single question being put on Amendments 11 to 13? No. The question is that Amendment 11 to 13 are agreed. Are we all agreed? Yes. We are agreed. I call Amendment 14 in the name of Maurice Golding, already debated with Amendment 10, and I remind members that if Amendment 14 is agreed to, I cannot call Amendment 24 down to preemption. Maurice Golding to move formally.
Moved.
Thank you. The question is that Amendment 14 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 25 in the name of Rachel Hamilton, already debated with Amendment 10. Rachel Hamilton to move or not move?
Not moved.
The amendment has not been moved, so will not be considered. No, 25.
24 fell.
It fell due to a preemption. I call Amendment 26 in the name of Rachel Hamilton, already debated with Amendment 10. Rachel Hamilton to move or not move?
Not moved.
The amendment has not been moved, so will not be considered. I call Amendment 15 in the name of Maurice Golding, already debated with Amendment 10. Maurice Golding to move formally.
Moved.
Thank you. The question is that Amendment 15 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 16 in the name of Maurice Golding, already debated with Amendment 10. Maurice Golding to move formally.
Moved.
The question is that Amendment 16 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 27 in the name of Rachel Hamilton, already debated with Amendment 10. Rachel Hamilton to move or not move?
Not moved.
The amendment has not been moved, so will not be considered. I call Amendment 28 in the name of Rachel Hamilton, already debated with Amendment 10. Rachel Hamilton to move or not move?
Not moved.
The motion has not been moved, so will not be considered. The question is that Section 4 be agreed to. Are we all agreed? Yes. I call Amendment 29 in the name of Rachel Hamilton, grouped with Amendments 30, 31, 17 and 18. Rachel Hamilton to move Amendment 29 and speak to all amendments in the group.
Thank you, Convener, and I move Amendment 29, which adds a reporting requirement into Section 5 review to include any concerns about the geographical distribution of dog theft and a consideration of whether a financial scheme should be introduced for kennel upgrades as previously outlined in Group 3, which I did not move. Amendment 30 and 31, also similar to previous amendments, both provide definitions for working gun dogs and allows definitions to be set by regulations. It's short and sharp, and I will leave it there. Thank you.
Maurice Golden to speak to Amendment 17 and other amendments in the group.
Thank you, Convener. In terms of my amendments, I'm acutely aware that this committee recommended in its Stage 1 report that Section 5 be removed from the bill, and the Minister has made her position clear on this too, and therefore, following discussions with ministers and officials, I've agreed to lodge Amendment 17, which removes Section 5 from the bill to give effect to the policy of removing the review requirement. Amendment 18 is a consequential amendment which removes the reference to review from the long title. I'd like to thank the committee, Rachel Hamilton, as well as the Minister and officials for constructive discussions through Stage 1 and 2.
Thank you. Minister.
Convener, this is a straightforward choice for members in this group. Support Maurice Golden's amendment, which will remove the duty under Section 5 for ministers to review the Act, or Rachel Hamilton's amendments that would add to the matters that the Scottish Government's review under Section 5 had to address. I encourage members to support Mr Golden's amendment. Convener, the Government's position on the review of the Act is that any such review is best undertaken by the Parliament, not the Government, and it is up to the Parliament and relevant committees to do that as they see fit with scrutiny. I'd urge committee to support Mr Golden's amendment and reject Ms Hamilton's. But if I could also just go on the record, I am very keen to work with Ms Hamilton moving forward to Stage 3, but also this is not my bill, it's Mr Golden, so I would encourage the member to also engage with Mr Golden.
Thank you, Minister. Rachel Hamilton to wind up and press or withdraw Amendment 29.
Well, I'm going to be cheeky, Convener, and say that I'm not sure if it is Maurice Golding's bill. It might be the Minister's bill, looking at the removal of Section 5. However, I do understand that Maurice Golding does need to be flexible to get his bill through and to work with the Government. I would contest the Minister's comment regarding the Scottish Ministers reviewing a piece of legislation, because that is a normal part of any amendment that, or any part of an act that ministers look to review the operation or the impact of an act. I don't accept the minister's comments, but to make life easy for the committee, I will not be moving these amendments. Thank you.
Thank you. The member has indicated they wish to withdraw the amendment. Does any member object? No, no member has objected, so the amendment is withdrawn. I call Amendment 30 in the name of Rachel Hamilton, already debated with Amendment 29. Rachel Hamilton to move or not move?
Not moved.
The member has indicated it's not moved, so it will not be considered. I call Amendment 31 in the name of Rachel Hamilton, already debated with Amendment 29. Rachel Hamilton to move or not move?
Not moved.
The amendment has not been moved, so will not be considered. I call Amendment 17 in the name of Maurice Golden, already debated with Amendment 29. Maurice Golden to move formally.
Moved.
The question is that Amendment 17 be agreed to. Are we all agreed?
Yes.
We are all agreed. The question is that Section 5 be agreed to. Are we all agreed? The question is that Section 6 to 8 be agreed to. Are we all agreed? Yes. We are. Thank you. I call Amendment 18 in the name of Maurice Golden, already debated with Amendment 29. Maurice Golden to move formally.
Moved.
The question is that Amendment 18 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that the long title be agreed to. Are we all agreed? We are all agreed, and that ends stage 2 consideration of the bill. And I suspend this meeting. We are not moving into private session, so I close this meeting. Thank you.